All
right, well, hello everyone. We're going to get this party started. My name is Alex Connect, and I'm the president of the Federalist Society here at Chicago, Kent. Obviously, we are here to talk about gun rights, the Second Amendment, gun control, mass shootings, and the like. We're here because of, recent events, much like the Sandy Hook tragedy, but it would be remiss of me if I did not point out that 1 year ago this morning, 6 students were shot in Sheldon, Ohio. So please keep in mind why we're here and what our goals are. I'm just going to run down the line of who the speakers are, and then they're going to take it from there. On my furthest left is our own Professor Sheldon Nahmod. He is a constitutional law expert as well as a Section 1983 law expert. He is a graduate of Harvard Law for his JD and his LLM. And you can find him online at nahmodlaw.com. Sitting next to him is John Malcolm. He's a senior fellow at the Heritage Foundation. He earned his undergraduate degree from Columbia and his JD also from Harvard Law School. His former posts include Assistant U.S. Attorney in Atlanta and Deputy Assistant Attorney General in the Department of Justice's Criminal Division. After leaving government work, Mr. Malcolm went to work for the Motion Picture Association of America, and he recently was the General Counsel for the U.S. Commission on International Religious Freedom. His work at the Heritage Foundation focuses mainly on criminal law, immigration, national security, and religious liberty issues, and he is also the head of the criminal law practice of the Federalist Society. Next to him is David Applegate. He is a trial attorney and partner at Williams, Montgomery & John Limited here in Chicago. He earned his undergraduate degree from Yale and his JD from the University of Chicago, if you've ever heard of it. Mr. Applegate has appeared on 60 Minutes, Fox Business Network, and his writings have appeared in the Trib, Daily Law Bulletin, Sports Illustrated, and Wall Street Journal. He's a fellow of the Litigation Council of America and a supporter of the Federalist Society, Heritage Foundation, the Cato Institute, and the Human Rights Campaign. He's also a model train enthusiast. To his right is Mr. Andre Queen. He is a member of Illinois Carry, a group that advocates for the right to concealed carry here in Illinois. For those of you who don't know, we are not allowed to conceal carry weapons here in the state until June 9th. He is the president of Fidelity Security and Investigative Services here in Chicago, and he is also an NRA certified instructor. To his right is Mr. Alan Kaufman. He is a practicing attorney here. He's an attorney for,
Manly D. Skahalski.
What's that?
Manly D. Skahalski.
Thank you. He's a Florida native, and he went to John Marshall Law School, so don't hold that against him. And then last but certainly not least is Mr. Doug Krick. He is the founder of the Pink Pistols, and for those of you who don't know the Pink Pistols, they are a LGBT group of gun owners who advocate for Second Amendment rights. Their aim is to reach the queer community and teach them how to operate firearms so that they are not targeted for hate crimes. If you have a chance, please check out the trailer for their documentary, Arming Laramie. So without further ado, Professor Sheldon Nahmod will kick this off.
Good afternoon. I want to thank the Federalist Society for inviting me. Alex, thank you in particular. And nice to see you all. I am going to say a few things about the Heller decision and its seminal Second Amendment ruling. I am then going to identify some open questions and make some concluding observations, and all of that will take 5 or 10 minutes before everything is opened up to my distinguished co-panelists. The Second Amendment's language is probably worth starting off with: a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. As just about everybody in this room knows, the Supreme Court 2008 decision by Justice Scalia, 5-4, court struck down a District of Columbia prohibition on the possession of usable handguns in the home. The court made very clear that in its view, the Second Amendment, despite the prefatory clause, was not limited to any connection with military service. Rather, the Second Amendment created an individual right, or codified a pre-existing individual right to possess and to use guns for traditionally lawful purposes, such as self-defense in the home. So that the prefatory clause does not itself limit or expand the scope of the operative clause. And the people have this individual right, and the court analogized this to the First Amendment and to the Fourth Amendment search and seizure clause. Court went into a very elaborate historical analysis. You could characterize it as the battle of law office historians. And as a result of this historical analysis, said that the Second Amendment did codify this individual pre-existing right to possess a handgun at home for self-defense purposes. The court referred to state constitutions of the late 19th and early 18th centuries, and it referred to the interpretation of the Second Amendment through the end of the 19th century, which recognized individual right under the Second Amendment. And it also pointed out that its precedents did not foreclose the conclusion that the Second Amendment gave rise to a personal or individual right. In the Miller case, this 1939 Supreme Court decision was distinguished. Now that most of you know, but it's particularly important to identify some dicta in the Supreme Court's decision, which are going to play a major role, already have played a major role in the litigation that is ongoing, which will ultimately reach the Supreme Court. First, Justice Scalia pointed out, and this is intriguing, most 19th century courts held that the Second Amendment did not ban prohibitions on carrying concealed weapons. And that's relevant in the Moore case and the Seventh Circuit decision and the brand new five-day-old decision, Peterson decision, just handed down in the 10th Circuit. Other limitations that Justice Scalia said are not disturbed really by its decision, the court's decision in the Heller case. Long-standing prohibitions on possession by felons and mentally ill of firearms. Those may still be in place. The carrying of firearms in sensitive places, such as schools and government buildings, those could still continue. Those were not supposedly being called into question. Imposing conditions and qualifications on the commercial sale of arms, Justice Scalia said, those are not really open to question. And the court, through Justice Scalia, said that there's a historical tradition of prohibiting the carrying of dangerous or unusual weapons, M16 rifles and the like. All of these were supposedly not covered by Heller. These were still in place. But in this case, the District of Columbia's total ban on handgun possession in the home, even for self-defense, went much too far. This was unconstitutional. Now, we lawyers and lawyer types know very well that there is no such thing as an absolute constitutional right. There simply is none. All of them involve some sort of test, some sort of level of scrutiny, which is really a variation of balancing. The Supreme Court specifically said that it was not applying a rational basis test in this Second Amendment scenario. What test was it going to apply? It didn't tell us. But no rational basis. It rejected the argument of Justice Breyer that there ought to be some sort of what Justice Scalia characterized as a free-floating balancing of interests test. Well, Thereafter, and to nobody's surprise, the Supreme Court held that while Heller specifically applied to the federal government, that the Second Amendment was incorporated by, for 4 justices, the Due Process Clause, for Justice Thomas, the Privileges or Immunities Clause of the 14th Amendment, and applied to the states. No surprise, the Supreme Court didn't work so hard in Heller only to get there and say only applicable to the federal government. So no great surprise there at all. Now, there are several open questions I want to call to your attention. And one I've already hinted at. Does the Second Amendment extend beyond the home to cover concealed weapons? The Seventh Circuit has held yes, in an opinion by Judge Posner. The Tenth Circuit has held no. And the Second Circuit may have implied yes, but. It's a more nuanced kind of decision. And if, in fact, the Second Amendment does apply beyond the home, the open question is, what is the standard of review going to be? All we know that it is not rational basis. It's more than that. My sense of the few opinions I've looked at that are out there in the circuits is that the courts are applying something like intermediate level scrutiny. Let me conclude with these general observations. First of all, the Second Amendment, as I understand it, is not a structural constitutional provision in the same way that the First Amendment is. Here's what I mean. You can connect the First Amendment to the entire Constitution, which is a document for self-government. And pretty clearly, the First Amendment along those lines not only creates individual rights, but it's directly related to self-government. I characterize that as structural in nature. I have difficulty seeing the Second Amendment as structural in nature in the same way I would have difficulty in seeing the Fourth Amendment as structural in nature, the Fifth, and the like. You get the idea. And my next observation is that it's fair to say, I think, that the court discovered this individual Second Amendment right to possess guns for self-defense in the home because we've had several centuries in which that was not the assumption, so one could say. Here's what's interesting to me as somebody who teaches and writes in the area of constitutional law. We have a new constitutional right. All we have is one opinion from the Supreme Court. How is it going to develop? The last time we saw anything like this, and some people may not appreciate the analogy, is Roe v. Wade, where the Supreme Court in 1973 came up with a woman's substantive due process right of woman to terminate a pregnancy, and it's been decades as the scope of this right has been working through the courts, and we can expect to see similar kinds of things going on, attempts to limit, attempts to broaden, as the circuits and ultimately the Supreme Court get to the scope of the Second Amendment right. And with that, I take my temporary leave. Thank you.
Thank you very much to the Federalist Society for inviting me to be here. There's obviously a lot I could say, more than I could say in the short time that I've been allotted for my initial remarks, so I assume that some of what I don't cover will come up in the Q&A period. Let me begin by stating an assumption that I think that all of us share, which is that what happened in December at the Sandy Hook Elementary School in Newtown, Connecticut was absolutely horrific, and that anybody who did not feel a great deal of pain in their heart that day simply doesn't have a heart. Nobody wants something like this to happen again, although I think we have to deal with the reality that it might happen, and in fact likely will happen. I think that it's very important in a situation like this, although people have a visceral reaction that they want to react and do something, is to step back, take a deep breath, look at all of the complex cultural factors that are in play, analyze the best data that is available, and then try to come up with measures that are likely to be as effective as one can be, while at the same time protecting our cherished civil liberties. And while some of the answers may end up lying with the federal government, I personally suspect that most of them will end up lying at the state and local level, which are given, by the way, primary responsibility for the police power of keeping us safe under our Constitution, and also have primary responsibility for treating the severely mentally ill who are the perpetrators of the vast majority of these mass shooting events. Let me state at the outset that I'm not a member of the NRA, and I've got absolutely nothing against Piers Morgan whatsoever. But what I do care about passionately is the Constitution. I also care about protecting the rights of law-abiding citizens to defend themselves in a dangerous world. And I also care about implementing sound public policy that does not impinge upon the constitutional rights of law-abiding citizens. Now, as Professor Nahmod has just said, the Supreme Court in Heller found that there was a fundamental individual right to possess a gun, a semi-automatic handgun, at least in the home. I would suggest, by the way, that finding that this was a fundamental right at least implies that strict scrutiny is likely to apply. As well, the majority opinion rejected Justice Breyer's dissenting opinion, which seemed more or less, although it was not clear, to be intermediate level scrutiny, but obviously the Supreme Court will flesh this out a little bit more in ensuing cases. Let me also say that there are many people, including many gun control proponents, but not all of them, who would just as soon take the Second Amendment and strip it out of the Constitution because they believe that it is dangerous and unsuitable to modern times. Now, not surprisingly, gun control proponents tend to focus on the ways in which violent criminals misuse certain firearms, and they tend to de-emphasize the way that law-abiding citizens use these same firearms for lawful defensive purposes. The framers of our Constitution were practical men, and they had dealt with people who had misused guns, and they also dealt with responsible citizens who used firearms appropriately for lawful defensive uses. And in propounding the Second Amendment, the framers decided to side with the latter, the responsible citizens, rather than the former. They were very aware that throughout English history, monarchs, including George III, had attempted to disarm pockets of rebellion, people who had firearms, and would then oppress them. Many modern dictators have done exactly the same thing. They have confiscated firearms from pockets of rebellion in order to subdue their citizens, and in some cases they have slaughtered them. I would posit that it's not by accident that the Second Amendment is followed by the Third Amendment, which severely limits the government's powers to quarter troops in people's homes. So a fear of an oppressive government is one of the animating features of the Second Amendment. That having been said, the Supreme Court, as Professor Nahmod just told you, has acknowledged that the Second Amendment is not absolute. They have said that the Second Amendment applies to weapons that were, quote, typically possessed by law-abiding citizens for lawful purposes, and with all respect to, due respect to Professor Nahmod, he said it does not apply to dangerous or unusual weapons. Actually, all guns are dangerous. I think everybody would acknowledge that, or they have the potential to be dangerous. The Supreme Court said it does not apply to dangerous and unusual weapons. What that is going to mean, of course, remains to be seen. Now, while not wanting in any way, shape, or form to minimize the terrible effects of gun violence, particularly with respect to mass shooting events, I think it's important that we maintain some perspective. Over the last 30 years in this country, the homicide rate has declined by over 50%. In 1980, the homicide rate in this country from firearms violence was 10.2 per 100,000 people. In 2011, it was 4.7 per 100,000. That is the lowest level since 1964, when it was 4.6 per 100,000. Now, at the same time that the homicide rate has been dropping dramatically, gun ownership in this country has increased dramatically. In 1964, the gun ownership rate was 0.45 per capita, so less than 1 out of every 2 Americans owned a firearm. And today it's estimated that there are more firearms in this country than there are Americans. Between 1991 and 2011, while the violent firearms crime rate was dropping, civilian firearms inventory grew by 66% and handgun inventory grew by 99%. Similarly, gun ownership is extremely high in some countries like Switzerland, Israel, New Zealand, and in Finland, yet the murder rates in those countries are extremely low. In this country, gun ownership rates are extremely high in rural areas, yet the firearms violence rate is much lower in the rural areas than it is here in urban areas. Now, not surprisingly, after Newtown, the immediate response, some might say the Pavlovian response, was to call for more gun control, including reenacting the so-called assault weapons ban that was in effect in this country from 1994 to 2004. It is worth noting, however, that after the assault weapons ban was allowed to lapse in 2004, the Department of Justice commissioned a study from some esteemed criminologists at the University of Pennsylvania in order to study its effects. And that study concluded, quote, "We cannot clearly credit the ban with any of the nation's recent drop in gun violence, and indeed, there has been no discernible reduction in the lethality and injuriousness of gun violence, based on indicators like the percentage of gun crimes resulting in death or the share of gunfire incidents resulting in injury. Should it be renewed, the ban's effects on gun violence are likely to be small at best, perhaps too small for reliable measure." It's also worth mentioning that during the decade that the assault weapons ban was in place, there were over 24 shootings that occurred at schools, including, of course, the infamous incident in Columbine, in which Dylan Harris and Eric Klebold killed 12 of their classmates, a teacher, and injured 27 other people before turning their guns on themselves. Now, this should not be too surprising. First of all, most gun crime in this country that results in death are committed not with assault weapons, but with handguns. Second, the term assault weapons was invented by gun control proponents for political and public relations reasons and has been applied to guns that look really mean. The term assault weapon has no firm definition other than the fact that it applies to certain firearms, certain cosmetic features, such as a folding stock or a flash suppressor on some semi-automatic weapons that make them look like fully automatic weapons, machine guns, which they are not. You know, you can take a Honda and you can dress it up to make it look like a Ferrari. But when you turn on the engine, it's still going to function like a Honda. In many cases, the weapons that were covered by the prior assault weapons ban were less powerful than guns that were not covered by the ban, and the same can be said for the current draft legislation that is being debated. In addition, criminals are usually pretty good at getting whatever guns that they want to use from the black market or by theft or via straw purchasers, and in addition to that, they're not stupid. So they could easily replace assault semi-automatic weapons that were banned with semi-automatic guns that were the functional equivalent that were not banned. If gun control by itself was the answer here, people would be much safer in countries like Brazil and Russia and Mexico that have much stricter gun control than we have in this country, when in fact the violent crime rates in those countries dramatically exceed those in this country. Similarly, you would expect to see high violent crime rates in states like North Dakota that have very lax gun control laws, when in fact the violent crime rate in North Dakota is quite low. And you would also expect to see very low violent crime rates in cities like Washington, D.C., and New York City and Oakland, and Chicago, which has the strictest gun control laws in the country, when in fact the violent crime rates in those four cities are persistently high. I would also note, by the way, that the violent crime rates in the 40s and 50s and 60s, when there was no real gun control to speak of, was very, very low. And that was at a time in which you could walk into a hardware store and you could buy guns and ammunition and dynamite. You could also buy rifles and shotguns out of a Sears Christmas catalog. Now, there's a lot more I could say about gun control, background checks and high-capacity magazines and guns in schools, but I'll leave some of that for Q&A. I do want to spend a few minutes in my opening remarks talking about something, a particular area in which I think we might be able to do something that helps to prevent massacres like Newtown, and that is specifically addressing mental illness. We need to recognize when we're talking about mental illness that there is a difference between mass shooting events, such as what happened at Newtown, and other forms of gun violence, like suicide, gang violence, drug-related violence, and domestic disputes. There are, unfortunately, some very deeply disturbed people out there. They are determined, they are psychotic, they are isolated, and they are often suicidal. And people who fit into this category are not deterred by the prospect of a long prison sentence or even by the prospect of the death penalty. The vast majority of these mass shooting events have been perpetrated by people who are severely mentally ill, who are not getting the treatment that they so desperately need. A study by Mother Jones magazine, hardly the kind of source you would expect someone from the Heritage Foundation to be citing, looked at 62 mass shooting events over the last 3 decades and determined that at least 38 of them, and they posited probably much more, were perpetrated by people who were, quote, displayed signs of mental health problems prior to the killings. A recent analysis of 20 studies determined that people with schizophrenia are far more likely to act violently. There's a 4-fold increase in terms of the violence rate among women who are schizophrenic, among men who are schizophrenic, and it's even higher among women. The risk of a schizophrenic, people who have suffered from paranoid delusions, committing a violent crime, are roughly 10 times that of the average citizen. Now, prior to the 60s, mass shooting events by these people would have likely been stopped because they would have been institutionalized. However, beginning in the mid-1960s, we began a deinstitutionalization movement. The Supreme Court issued some opinions that furthered that movement, releasing these severely mentally ill people into the community where they could get treatment. Unfortunately, they did not, and they have not. According to the National Institute of Mental Health, there are approximately 7.7 million Americans who are severely mentally ill, and 3.5 million of them are going untreated. Recent studies have suggested, though, that psychiatrists looking at risk assessment factors are doing a better job at being able to pick out which severely mentally ill people are likely to commit violence. Other studies have shown that states that have overly restrictive civil commitment laws, make it difficult for somebody to be civilly committed, are far more likely, 1/3 more likely, to suffer violence at the hands of severely mentally ill people who live in their communities. I think that it is time to reevaluate, for the states to reevaluate some of these civil commitment laws and the mix and amount of resources that they devote to treating the severely mentally ill people who live in their community. And of course, once people are adjudicated mentally ill, that should be entered into a background check system. Let me close with one quote, if I may, from Thomas Paine, who wrote the following: "The supposed quietude of a good man allures the ruffian, while on the other hand, arms, like laws, discourage and keep the invader and plunderer in awe and preserve order in the world as property. The same balance would be preserved were all the world destitute of arms, for all would be alike. But since some will not, others dare not lay them aside. Horrid mischief would ensue were the law-abiding deprived of the use of them." Thank you.
You're right about and. I misread my own handwriting. Oh, no, that's right.
Thank you, Alex. Thanks to
the opinion.
IIT Chicago-Kent Law School and to its student chapter of the Federalist Society for Law and Public Policy Studies for having me here today among such a distinguished panel. My name is David Applegate. I am a private practitioner here in Chicago, as you heard. I've done a lot of thinking and reading about the Constitution. Unlike Professor Nahmod, I am not a constitutional law professor. Repetition being the key to learning, you're going to hear some things from me that you've heard from the previous speakers and may hear from subsequent speakers. Critical thinking being part of why you were in law school and part of why you were here. I'm going to disagree with some things, I'm sure. I'm going to raise some questions. But most of all, what I'm going to try to give you through the benefit of what I think is my knowledge, experience, thinking, and reading, however correct or incorrect it may be, is a prism for looking at these issues, for how to read and understand the Constitution in general, and in considering the Second Amendment issues in particular. Because, like it or not, ladies and gentlemen, you are the leaders and thinkers of tomorrow. Some of us with a little more gray hair are not going to be around quite as long as you, most likely, to solve some of these problems, and whatever I and I'm sure the other panelists can do here today to help you think about some of these problems is what we're here for. So let's begin, as Professor Nahmod did, of course, with the language of the Second Amendment, which I hope everyone has read it in its entirety. It's essentially 5 phrases. And all this debate and all this discussion for 200 years of commentary from Blackstone and Madison through Judge Posner and David Hamilton on the 7th Circuit to the 10th Circuit today, boils around these 5 phrases. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. But as it says at the bottom of the slide, what does this mean? The focus of many of the cases and the commentators is on a few of these words or phrase, and of course, the big battle is between a well-regulated militia, on the one hand, people who want to say that there is no right, as Justice Stevens did in his dissent in the Heller decision, there is no right to keep and bear arms in this country, independent of service in the military, or is it a right retained by the people? The same people who drafted the Declaration of Independence, the Constitution of the United States of America, and their heirs today, who include the people sitting and standing in this room. A free state, is this something that applies against the states, or does it apply only at the federal level? The right of the people. Again, if we recognize a right, and Justice Stevens says, all right, the Supreme Court says this is a right of the people, the language says it's a right of the people, but is it an individual right, or is it a collective right? To keep and bear arms. What does this mean? Does it mean you can keep them locked safely in your gun safe, provided they're disassembled, the ammunition is located elsewhere, and they all have nice child-safe trigger locks so that no one can access them? Or can you take them out in public, display them, and use them? As one of our great American heroes, which we hope you're all familiar with, Captain America. Arms, what does that mean? Does it mean a flintlock pistol of 18th or 19th century variety? Or does it mean the AR-15 that supporters call the modern musket? Is it limited to handguns? If so, is a Colt 45 revolver okay? Or can you have a pistol? Can you have a really neat, cool-looking pistol? Can you have lots of pistols? These are all questions that people have tried to answer that remain unanswered, and I hope, as I said, to give you some perhaps new ways of thinking about this. Shall not be infringed. What does that mean? Is this an absolute ban on gun control? We know you can't absolutely ban guns in light of Heller. But is there an absolute ban on gun control, or can it be reasonably restricted in some way? Professor Nahmod adverted to the Miller case in 1939. This was a Depression-era, Prohibition-era case involving a criminal statute, and for the 1934 National Firearms Act, which outlawed Thompson-style submachine guns and sawed-off shotguns, which were regulation shotguns that maybe farmers kept, hunters kept, for duck hunting, skeet shooting like the president engages in, that sort of thing. But they sawed the barrels off so that they could conceal them, make them easier to carry and use for criminal purposes. So in examining a conviction under the National Firearms Act in Miller, the United States Supreme Court said there's no evidence of any reasonable relationship of a sawed-off shotgun, for example, to the militia. But with respect to the militia, it made 2 interesting observations. One was that the militia, in common law, was all males. Sorry, ladies, you are included today, don't worry. But in 1934, it was all males physically capable of acting in concert for common defense. This is used by proponents of gun rights restrictions, people who want to say there should be no collective rights, only if you serve in the militia. But Miller also said, interestingly, that the militia, acting through these people, had to supply their own arms, and they were the kind of arms in common use. Now, that's updated, of course, to today, but one of the phrases that you should think about is, what is an arm in common use? What does that mean? What should it mean today? So then we get to Heller in 2008, and as you all know, it said there is an individual right to possess a firearm that is not connected with service in the militia, provided you use it for lawful purposes, such as self-defense within the home. It is not a right to keep and carry absolutely any weapon whatsoever, in any manner whatsoever, for any purpose whatsoever. And a total ban on handguns in the home is unconstitutional. What the named plaintiff, who actually made it to the Supreme Court, because there were 6, but 5 did not have standing, who eventually got to the Supreme Court, all he wanted to do was to have the District of Columbia issue him a permit to have a loaded firearm in the home. So that's as far as the court had to go. And that's what it did. It said, no, this total ban is unconstitutional. As Professor Nahmod said, Justice Scalia even referred to certain long-standing prohibitions that were recognized, things like concealed weapons, possession by felons and the mentally ill, carrying guns in sensitive places like schools and government buildings, the conditions and qualifications for the commercial sale of arms. But look at that. He says some reasonable restrictions were possession by certain categories of people and carrying in certain places. Doesn't that imply a right to carry? Why do we need to talk about carrying firearms in sensitive places if you have no right to carry them anyway? So maybe not strictly part of the holding, but a suggestion in Heller that yes, the right to keep and bear arms implies a right to carry. A question explicitly left open was whether it applied to the states, and that was answered, as we all know, in a case against our own city of Chicago, Donald, in 2010, addressed that question, does the Second Amendment apply against the states? The answer was yes. Among other reasons, the court said it's fundamental to a scheme of ordered liberty. Self-defense is a basic right. Handguns are the most preferred firearms in the nation. And the question that it, again, only arguably left open, depending on how you want to read Heller, is whether there's a right to carry outside the home. That then takes us to another decision out here in Chicago, our own Judge Posner, in Moore versus Madigan, who just a couple of months ago on December 11 of 2012, said, yes, the answer to that question, is there a right to carry outside the home, in view of Heller, has to be yes. Because Heller is just about self-defense. The need for self-defense is most acute outside the home, not inside the home. We could not rationally limit this right to inside the home. He says the surveys of the social science evidence are indeterminate, although he reviews them at great length. And the history has been resolved by Heller. So we really need to go no further, but this cannot be limited to inside the home. The Illinois unlawful weapons statute, which in part makes it unlawful to carry a loaded weapon that is operable outside your home, is flatly unconstitutional. We don't need to hear any more evidence on it. I'm going to give the state of Illinois 180 days to redraft it, but that's as far as we need to go. As you heard, we recently had a petition by Attorney General Lisa Madigan to rehear the case on bonk. That was voted down 5-4. 4 people said they would take it, 5 said they would not. And David Hamilton, a 7th Circuit judge out of Indianapolis, actually wrote a dissent from the denial of the petition to rehear it on bonk. And he disagreed, of course, with the majority, disagreed with the decision not to hear it on bonk. And he spoke about the qualitative differences between inside the home and outside the home. Difference between private homes and public streets and buildings. Made a real distinction between the public sphere and the private sphere, which I hope we'll get to in the questions and answers. But think about this. If the Second Amendment right is akin to a fundamental right, is a fundamental right akin to the First Amendment, which is one area where I am going to disagree with Professor Nahmod, should the First Amendment right be limited to inside the home? Do you lose that right when you step outside the home? Should this apply to other rights? Again, I may be wrong, I may be right, but this is something that I urge each and every one of you to think about. But David Hamilton did make this distinction, and he also provided what many have regarded as a roadmap for the Illinois State Legislature, because the legislature now has until June 11 or 12 or thereabouts to come up with a new statute. So he pointed out very helpfully in his dissent what the panel did not decide. It did not decide who may carry a loaded weapon outside the home. It did not decide where outside the home qualified persons may carry firearms in public. The majority did not side, or yes, the majority panel decision did not decide how qualified persons may carry weapons outside the home. That is, concealed weapons or open carry. What kind of place, what kind of circumstance? And finally, Judge Posen and Judge Flaum, in their majority opinion, did not decide which arms may be carried in public. With respect to who may carry, he said, well, it's obvious. You can't have a felony conviction, mental illness. We can have reasonable requirements for firearms training and so forth. And he even questioned whether, as the Second Circuit has done, you can require proper cause before you issue a permit. Then he speculated on many of the places, which I'm not going to run through in the interest of time, but he says if you can't carry them in schools and public buildings, maybe you could extend them to all these other areas. And he listed about 20 of them, quote, among many other possible examples. By the end of running that list, of course, there was no place outside the home. He agrees that no M1A1 tanks, but you're not limited to arms at the time. He points out the majority of 19th century courts upheld prohibitions on concealed weapons, but said that in our modern society, open weapons can be intimidating or disruptive. So again, what's left?
Okay.
Then we have the Martinez case, decided just the other day, that said there's no concealed right, which we can discuss further in the Q&A. So let's get now to, here's just a list, a summary of decided and undecided issues. But let's get to what I call this holistic approach to the Constitution. A piecemeal approach looks at phrases in isolation. A holistic approach looks at the entire document. Piecemeal ignores certain words, holistic says every word counts. Instead of focusing on the outcome, focus on the intent. Look at structural arguments instead of policy arguments. Instead of assuming there's a change in meaning, it's a living, breathing document that means whatever we want it to mean, depending on who sits on the Supreme Court, that it has a consistent meaning, and read it in the context of the Declaration of Independence. The Declaration of Independence says certain truths are self-evident. The Constitution begins with we, the people. We are endowed with our Creator by certain unalienable rights. So the Constitution doesn't create rights, it puts limits on what government can do to limit those rights. The Declaration says among these rights are life, liberty, and the pursuit of happiness. The Constitution says explicitly in the 10th Amendment the enumeration of certain rights does not disparage or diminish the existence of others. The Declaration of Independence talks about free and independent states. The Constitution in the 9th Amendment says that unnamed, unalienable rights are retained by the states and by the people respectively. I'm going to skip over these specific examples about quartering troops and so forth in the interest of time. And let me turn to a very simple equation that will help you, I hope, as much as it helps me in remembering and understanding the Constitution. And that's 7 plus 3 equals 10. If you can remember that one equation, that's all you need to understand the United States Constitution. It's not a big document. You can find pocket-sized editions that include the Declaration, the Constitution, in some cases the Gettysburg Address. But there are 7 articles, there are 3 branches of government, and there are 10 original amendments in the Bill of Rights. And there's a consistent structural theme to this, I see. And this is where I start to disagree with Professor Nahmod on whether Second Amendment rights are structural or not. Article 1, of course, sets forth the legislature and military powers. Article 2 provides for the executive branch. Article 3 provides for the Supreme Court and such lesser courts as the Congress may create. There's your 3 branches of government. Article 4 concerns the states. Article 5 is the amendment process. Article 6 says the Constitution is the supreme law of the land. And then Article 7 deals with ratification. Let's turn briefly now to the Bill of Rights, which are the first 10 amendments. I submit there are 4 major groupings. There's the First Amendment. It stands alone. The Second and Third Amendments, the Fourth through Eighth Amendments, and then the 9th and 10th Amendments. First Amendment you're probably most familiar with. It protects 4 basic freedoms: freedom of religion, of speech and the press, right peaceably to assemble, and petition the government for redress of grievances. And if you think about that, that starts from the premise that we are endowed by our Creator with certain unalienable rights. As soon as you are born, as soon as you become a person, you can start to form thoughts and ideas. And you can believe whatever you want to believe about a supreme being, or the absence or non-existence of a supreme being. And then you can go and tell other people about it, not just your friends, but you can tell them in the press. And then you can peacefully assemble to tell people about your ideas and hold forums like we're holding today. And then you can even petition the government for redress of grievances. So those are rights that spring from the individual and they work outward in a circle to the public square. Then we have the Second and the Third Amendments, as John Malcolm was indicating. The second says there is a civilian right to keep and bear arms, whether you agree with the Justice Stevens dissent in Heller, or whether you agree with the majority, there's a collective right or an individual right. It's definitely a civilian right to keep and bear arms. The Third Amendment says no quartering of troops. And there is a consistent theme I submitted, as John Malcolm has suggested, to those 2 amendments. And it's protection of the people, we the people, who make up this country, who declare our independence from a monarchy, protects us from the coercion, the coercive power of the state, and from standing armies. Second and Third Amendments, in a nutshell, very simple. Then the Fourth through the Eighth Amendments deal with the stages of a criminal proceeding, from probable cause for arrest, unreasonable search and seizure, due process at trial, right to a counsel, trial by jury, and no cruel and unusual punishment. So there you have it, from the arrest to the sentencing, a very coherent structural layout. Then in the 9th and 10th Amendments, you have the structural protections that say, just because certain rights are enumerated in the Bill of Rights doesn't mean you don't have other rights. And they shall not be construed in any way to disparage the rights retained by the people. And the 10th says power is not delegated to the U.S. nor prohibited to the states or reserved to the states respectively to the people. That, ladies and gentlemen, is the Constitution in a nutshell. The rest of it, I submit, is just gravy. But what we have is a government of limited powers that derives its just consent, or its power from the just consent of the people. And when in doubt, the presumption should be in favor of liberty and individual rights, not the coercive power of the state. No rights are absolute, of course. I'm going to just let you read the slide on that one. But keep in mind the difference between what is constitutional and what's a policy argument. A lot of people opposed to the death penalty. Many nations have done away with it. Maybe the United States should do away with it. But it is constitutional. How do we know it? Because the Fifth Amendment talks about it. It talks about capital crimes. It says you should never be twice put in jeopardy of life or limb, or deprived of life without due process of law. So it has to be constitutional. But there are lots of policy arguments against it. It's not required. It may be uncivilized. It could be unwise. It's irreversible, after all, if it's actually carried out. It may be unfairly applied, and so it may violate equal protection. It may just be too yucky. If you're going to have it, you have to find a way to kill somebody. How are you going to do that? Some of these things are very messy. But in and of itself, it's not against the Constitution. So just because something is constitutional does not mean it's required. But if it is unconstitutional, you simply can't do it. Where does that leave us? That leaves us in the realm of policy, which I think our next 3 speakers are going to talk about mostly. I'm putting up on the board some of the not so much arguments, but slogans pro and con about guns, what's good, what's bad. But where we are is that firearms are okay. It's an individual right. You have a right to keep. You have some kind of right to use them, but the use must be lawful. The right itself cannot be infringed, but rights can be reasonably restricted according to time, place, and manner, and category of owner. These are some questions you might want to think about. What's okay? What kinds of buildings? Places you can take them. Background checks, mental competence, felony convictions. Should they be licensed? The age limits, training limits, insurance requirements. What about registration? The if you have a gun legally, what happens when we die? Does it revert to the state? Can you leave it to your heirs? Maybe, though, what we need is a compromise. What we should have is nice-looking, non-scary, modern weapons, modern muskets wielded only by non-threatening persons of color and gender. Here, John Malcolm's perfect example of a gun that we can make not to look scary. This is the Hello Kitty version of the AR-15, and I will leave you there.
I think my wife has the version of the Hello Kitty AR-15. So, good afternoon. My name is Andre Queen. I'm here as a representative of IllinoisCarry.com, which is a grassroots organization established here in the state of Illinois for the purpose of bringing about concealed carry. And we've been working on this for a very, very long period of time. My particular area of expertise pertains to training. I'm president of Fidelity Security and Investigative Services here in Chicago. Our forte actually is training. When the Chicago Firearm Permit Program came into being, we were the first organization to provide that training to citizens here in the state of Illinois. We've been loved by the city of Chicago for that ever since. One of our esteemed students is actually Rhonda Ezell, who was the lead plaintiff in the Ezell versus City of Chicago, the gun range ban lawsuit that's still active. I want to talk a little bit about the practicalities of what this will look like from a training standpoint. To a great degree, that's going to be framed primarily by the law and how we understand the Second Amendment and how that's going to unfold within our state. And it's pretty interesting to see how that's going to look. One of the things that we do need to understand is that the government does have a compelling interest in gun ownership among the citizens. There are a lot of pros and cons both ways, but I know a lot of individuals would be surprised to understand that our federal government wants individuals to be properly trained in firearms. There are a number of different reasons why. The U.S. government sponsors a program called the Civilian Marksmanship Program, which is a federally subsidized program in which U.S. citizens are trained in the use of firearms from the World War II era firearms, which I guess under some definitions here in Chicago would be considered assault weapons. But a trained citizenry certainly enhances public safety. Trained citizens make better soldiers. When and if we have to go to war, there's less time spent getting them ready and prepared in boot camp and things of that nature. And certainly here at home, when we consider the issue of crime, as we are here in Chicago, as we're faced with that, the question many people have on their minds is whether or not license to carry, right to carry, will actually reduce crime. What we have seen in other states indicates that where we have one crime, where a crime is committed, where you have one individual that does not know the actual victim, we see crime does in fact drop. We're expecting to see something similar here in Chicago. There's been much made about the homicide rate here in Chicago, and our esteemed superintendent indicates that we have a gun problem here in Chicago. Well, I would submit to you that we don't have a gun problem here in Chicago. What we do have is a gang problem, and we've had a gang problem for several generations here in Chicago, and the more that we have that and our lack of ability to properly convict those individuals and to keep them in jail for long periods of time, that is primarily our issue there. But with regard to the practicalities of training individuals for concealed carry, there are two general schools of thought on this, two different models that we're seeing throughout the United States. The first model is what I like to call the Utah model, based upon the Utah Concealed Carry Permit Program. Now, the Utah model of training requires an individual who applies for a concealed carry permit to go and attend a 4-hour or 6-hour course of instruction. And the course itself is designed to teach an individual about the laws of firearms and use of force within the state of within the state of Utah, and also to teach them about firearms and handgun safety. It does not require a range requirement. The individual simply needs to take the course and then apply for the actual permit. The strength of the Utah permit is based upon its background check program. Now, Utah is different from most states in terms of when an individual applies for a concealed carry permit. They, of course, go through various state and federal background checks. Utah is unique, however. Its citizens, once they receive a concealed carry permit, they go through that background check once every 30 days for as long as the individual has the permit. There's a continual background check process to ensure that only the right kind of people get the permit and only the right kind of people actually keep the permit. And because of the strength of that continuous background check process, it's recognized by so many other states. Now, non-resident permit holders of the Utah permit, such as myself, I have a Utah concealed carry permit, we go through that process once every 3 months. Our background is checked automatically through the Bureau of Criminal Identification in Utah, again, to ensure that only the proper people keep that particular permit. The other model I like to call the Florida model. The Florida model is predicated upon training that requires you to go to the range and qualify with a firearm that you're going to be utilizing. And there are many states that recognize the Florida permit specifically because, in addition to the classroom training, you must also then go to a class and then go out to the range and then do live fire training, achieve a particular score, and then you can then apply for the permit and go through the usual background checks. Most states follow either one or the other of these in terms of their licensing program. We are seeing the advent of something that's neither this nor there that we call constitutional carry. Now, constitutional carry states simply state that as long as you are an individual that may legally own a firearm, you're not prohibited by federal law, you're not prohibited by state law, you're not suffering some mental disease or defect, you may apply, you may simply carry a firearm on your person. You are lawfully allowed to do so. As they would say in the southern states, I guess, with a little bit of a twang, you know, the Constitution is my permit, right? So we're seeing more and more of that. So you have the two different types of permits, and then you have the constitutional carry, and then you have us, the last state, you know, the last man standing, as it were. So now we're trying to find out where we fit into this process. One of the things that we need to keep in mind, excuse me, one of the things we need to keep in mind is that the process, however it unfolds, it needs to take into account the access to this permit by those individuals who truly need it. Particularly individuals who are poor, who live on fixed incomes, who come from very meager means. So in terms of the licensing, the fees, and the cost, if we're not careful, we can see something akin to a poll tax during the civil rights fights. We can see something that inherently becomes unconstitutional insofar as the cost of getting the permit is prohibited for individuals who cannot financially afford to do so. So that's something that we want to take into consideration. We also want to think about how this is going to unfold from a city standpoint. You know, we think of Chicago, and I understand from having spoken to some of our aldermen that Chicago thinks it's a state unto itself, but it isn't. It necessarily brings the rest of the state of Illinois along with it. So we have to look at a permit that's going to be good for the entire state as a whole. So that means we have to ask the question about home rule law here in Illinois. Do we allow home rule exemption? Do we make one permit for all citizens of the state? Or do we allow carve-outs for cities like Chicago or for Cook County, which is also a home rule unit of government? So these are things that we need to concern ourselves with in terms of how this is going to unfold. There are a number of different ways in which the training can be done in terms of classroom work, in terms of range training. Both of those are issues that we have to take a look at. There are no ranges in the city of Chicago. So for an individual who lives in the city who does not have a car, you then have to travel to the suburbs. And how exactly do you do that if you don't own a car? How do you do it on Metro? How do you do it on Pace? Does it even go in that particular direction? And will you be standing next to a bus stop at 6 p.m. because the buses have stopped running? Ask me how I know. Really what we're looking at here is kind of cause and effect. We're looking at the crime rate here in Chicago and we're saying, well, guns are the problem. But we really need to ask ourselves, is that necessarily the case? Or is it that the criminals are the problem? We're very much concerned about legislating the guns in the hands of the law-abiding citizen, but we're not focusing necessarily on the actions of the criminals. We're not focusing on the criminality itself, nor, unfortunately, are we focusing on the mental ill issues. Because licensing must necessarily, consider individuals who are suffering from mental disease or defect. The mass shootings that we've seen have happened as a result of individuals who are suffering from some form of mental illness. So we need to really address that. So these are the actual considerations that we really want to be thinking about in terms of training individuals, because we already, in some sense, we already do have citizens here in the state of Illinois that carry concealed. Some of them are called aldermen, okay? But some of them are called security officers. Some of them are called private investigators. We have a wide variety of them who are retired police officers who carry under the federal retired law enforcement officer code. They carry concealed weapons. They're no longer police officers, they're ordinary citizens. So we already have concealed carry to some extent, but what we don't have is equity. We don't have equity for all of our citizens. What we have is a version of Animal Farm, where all animals are equal, but just some are a little more equal than others. And that's really what we need to remedy. It isn't an issue as to whether or not we're going to do concealed carry. We are going to do this. It's necessary that we do it properly to make sure that every citizen who qualifies and who wants to avail themselves of this right has the ability to do so and is not precluded from doing so by the government that is here to serve them. Thank you.
Hello, thank you for having me here. My name is Alan Kaufman. As Alex mentioned, I grew up in Florida. I moved here for law school, and while I was in Florida, I could carry a gun. And when I moved here, I couldn't. And that's kind of when I joined Illinois Carry, and I got involved with the right to carry, activism, because in Florida, it was no big deal. Everyone's got a gun. I went to visit a friend in Florida, and I got in the car, and he handed me his new Glock that he just got. Perfectly legal, nothing wrong with that. If I did that in Chicago, I'd be arrested. So let me just kind of set up what I think we need to talk about as far as the question and answer session goes. I'll try to keep this brief. I don't know if any of you read the paper, but yesterday, House Bill 1155 was debated for 8.5 hours yesterday, and I listened to most of it. I'll try to give you a quick breakdown of it. It amounted to political theater. Mike Madigan decided that he was going to propose a concealed carry bill, and he was going to allow it to be debated on the House floor as a blank bill. It's called a shell bill. He introduced 1155, says absolutely nothing about concealed carry whatsoever. Amendment number 1 is introduced. It's now a concealed carry bill. And then as the night went on, it started off with 22 amendments and 27 amendments, and then I think by around 9 o'clock, there were 30-some odd amendments to this bill. House Amendment number 2 was prohibiting, if I'm trying to quote this right, prohibiting guns near, in, or about schools and the parking lots and any property adjacent thereto. Now, of course, near wasn't defined and adjacent wasn't defined, and that amendment passed. So what's really going on here is Mike Madigan is playing politics with the 7th Circuit decision. He wants to get pro-gun representatives on the record voting for or against guns in schools. Now, everyone in this room who's going to be an attorney or is an attorney knows you can't have a statute that says near or close to or adjacent to. In our criminal code, when you've got drug violations, 1,000 feet of a school, 500 feet of a school. No, just says near, that's fine. You can figure it out. Well, in terms of planes, a mile apart is a near miss, right? So I guess a mile is near. And the night went on, and then we did what else did we do? We did the public transportation. So you can't have it anywhere near, on, or about close to public transportation. But you can have it on sidewalks. They let sidewalks slide, sort of, unless they're near or adjacent to a school. So say you want to take let's pretend we're downtown Chicago. I've got an Illinois permit under this bill, and I want to get onto the CTA. Well, I'm okay as long as I'm on the sidewalk and I'm not near or adjacent to a school or the 10 other places that they went on to name. So let's pretend I'm in the middle of a sidewalk in the middle of nowhere and there's a bus. So I want to get on the bus. Well, I can't actually take my concealed weapon on the bus because there's a rule against that now. So now what I have to do is I have to unconceal it, take it out of the holster, and I have to unload it, put it in a case, take all the bullets out of it, in the middle of the street, and then get on the bus. Then when I get off the bus, then now I can have the gun again. So now I have to take it out of the case, put the bullets back in it, load it back up, put it back in the holster. That's what they were discussing last night. That's literally what was passed last night, or not passed, but argued about last night. And then it gets even better. So Amendment 27 is actually House Bill 99, or mostly House Bill 997, which was the concealed carry bill. And House Bill 997 says you can have a gun in the school as long as you keep it locked up in your trunk, or as long as it doesn't leave your car. And the idea is if you're a parent picking up your kid from school and you're concealed carry, we don't want to charge this person with a crime, so as long as they stay in their car, that's not a criminal act. That makes sense. Well, unfortunately, you've got Amendment number 2, which says you can't be on, near, or adjacent. So now you've got a bill that says, yeah, it's okay to have a gun in your car, but not if you're on, near, or adjacent to the school property. It's a disaster. That's what our representatives spent 8 hours doing last night. So you can find it online. It's on livestream.com, the Blue Room stream. Just, you don't need to watch all 8 hours of it. You can watch the first 20 minutes of it and get an idea of where it's going. Representative Robletti and Jack Franks, Robletti who's a Republican, Jack Franks who's a Democrat, drilled these people because it was clear that they're just playing political games. They wanted to get these representatives, your representatives, on the record saying guns in schools, no guns in schools, even though we all know that it was stupid. The way it was written was just absolutely ridiculous. So that's what our representatives are wasting our time with. So June 9th is closely ticking along. So hopefully as we get closer to June 9th, they'll get serious about it. But right now, it's a joke. It's just a big joke to them. It's a political game. So that's what's going on as far as the Illinois legislature goes. I encourage you, watch some of the video. You'll be appalled by what our representatives have been doing. I'm also an attorney, so we can talk a little bit about, I can talk about law too. I'm obviously not a constitutional attorney, but it is one of my hobbies. I'm kind of a Second Amendment nerd when it comes to this kind of stuff. So I actually do agree that there's no constitutional right to concealed carry. I actually agree with that. And it goes back to a case which is cited by Heller, and it's Nunn versus State. And in this sentence where Scalia says prohibitions on concealed carry are traditionally constitutional, he immediately cites Nunn versus State. Nunn versus State is a case from the 1800s, the Supreme Court of Georgia, where the Supreme Court of Georgia dealt not only with a concealed carry ban, they also dealt with an assault weapon ban. They were dealing with 1800s assault weapon ban, but we can talk about that too. So the law that the Supreme Court of Georgia was dealing with is very poorly written, and the Supreme Court says as much. But what they were dealing with was a horse pistol was okay, but a breast pistol was not okay. Does that sound familiar? A hunting rifle is okay, but don't make it a black plastic rifle. That's not okay. They both do they're both rifles. They both do the function exactly the same thing, shoot the same kind of bullets, but one looks scary or the other. And Supreme Court of Georgia said, no, you can't do that. That's unconstitutional. You can't infringe upon the right of self-defense in such a way. They also dealt with the concealed carry issue. And what they said as far as concealed carry goes is you don't have a constitutional right to concealed carry. However, you can't pass a law in such a way that destroys the right to keep and bear arms. So the constitutionally protected right is to openly carry. So the Supreme Court of Georgia said you can either allow open carry or concealed carry. You can't ban both. That's the distinction. So Justice Posner, I heard some of the speakers say, you know, Judge Posner struck down Illinois' ban on concealed carry. No, he didn't. Read it again. Judge Posner struck down Illinois' ban on carrying operable firearms in public, period. He didn't say that Illinois had passed a concealed carry law. He didn't say that we had to pass an open carry law. He said that the ban on carrying arms in public is unconstitutional. It's exactly the same thing the Supreme Court of Georgia said in Nunn versus State in the 1800s. It's not revolutionary. This idea has been around for a very long time. He didn't adopt the opinion from the Supreme Court of Georgia because the Supreme Court of Georgia also said that the Second Amendment is an unrestricted right. So obviously that portion of the opinion was not adopted by Heller, not adopted by Scalia in his opinion. But it's there. It's a very interesting case. I encourage you to read it if you haven't. You all have free Westlaw and Lexis accounts. So it's an interesting read. So that's where we are. We don't know what the bill is going to look like. I would suppose to you that there are a lot of straw man arguments going on right now. The big straw man argument right now is that we don't want the guns on public transportation. I grew up in Florida. I've been to Miami. Been carrying guns in Miami on public transportation. It's not an issue. It's not an issue in any of the 49 states have concealed carry. It's a fake issue. There are lots of these, alarmist issues that get raised, that simply are not the case. So with that, I'll pass it on. I think I've kind of set the table for a good discussion, and I'll be happy to answer any questions you guys have. Thank you.
I'm probably the one person here who is the least informed. I got to where I am through luck and just good timing. I started with the Pink Pistols back in Boston in July 2000. We came about because my girlfriend, my roommate, myself, and a few friends wanted to go shooting. And we wanted to do it on a regular basis. So we got together and went for a shoot and had fun. Well, we wanted to do it again and coordinate, and more people wanted to join up. So, okay, how are we going to do this? Email, website. Oh, bloody heck, we got to come up with a name. About the same time, ran across an article by Jonathan Rausch called The Pink Pistols, encouraging people of alternative sexuality to join a shooting group, let people know that we're shooting. We thought, hey, wait a minute. Every one of us happens to be either bi, gay, polyamorous, into BDSM, some kind of alternative sexuality. Let's use it. So we wrote him and asked permission and got it. And you know how those things go viral on the internet? We went viral almost overnight. In under a month, another person from Virginia contacted me and said, hey, I want to set up a chapter. Can I play, please, please, please? Sure, have fun, join. So next thing I know, someone came up with a logo. Another person came up with pins. Someone else was making hats. And okay, wasn't quite expecting this, but we're all just having fun. And then I went, let's play with the media's mind. I had run for state representative in Massachusetts, so I had a national fax list. So I put out a fax saying, hey, the Pink Pistols exist, pretty much. I wasn't expecting Newsweek to bite. They ran a small blurb on us. Next thing I know, I'm getting people from across the country contacting me saying, hey, I want to play, okay. Next thing I know, I find myself in front of a national movement, which went international for a little bit. And another guy came up with some art. Do we have? Okay. He's going to talk about art. Okay, I'll come back to it. Shortly after this was going, someone contacted us, an attorney, saying, hey, we're filing with the U.S. Supreme Court. I think it was the McDonald case. PPHR? Yeah. That logo was created, and another guy by the name of Oleg Volk, he ended up staying up here. We're going to go through a couple of these quickly. Oleg is a member of the former Soviet Union, political and refugee, and he spent his professional time giving away free artwork for the gun rights movement. And he came up with this logo for our website. Never. Yeah. When he came up with this one for us, Some people went, hey, wait a minute, never again? That's the Jewish community. We might offend people. And then the Israeli Americans that I knew, I went, wait a minute, you guys were involved in it too. You have the right to use that logo and slogan. So that quickly went up on the website. Oh, okay. The pink triangle, as the Jews had to wear the Star of David on their clothing, the homosexuals had to wear the pink triangle on their clothing, and they were sent to the same death camps. Just for a little background. Arm gaze.
Top.
And this one is another logo that came up, and all of a sudden people started saying, hey, that's our slogan. Oh, I didn't realize we were that organized. But a few more images just to quickly go through, just the rest of them in any order, just to give you an idea of the type of imagery we're going through. I mean, I think this one's self-explanatory, is it not? Would you rather have a gun or a condom? Yeah. It's okay. Because, well, I think that's enough. At any rate, the attorney asked us if we'd be interested in doing an amicus curiae brief. And we said, yeah, be happy to do so, maybe. Let me talk to my lawyer. And as a member of the Boston Pink Pistols at the time, there was a lawyer who was a member of the U.S. Supreme Court, whatever the term is. You're the lawyers, not me.
Bar.
At any rate, she donated her time pro bono. We just passed the hat for the printing costs, about $200. Next thing I know, 2 other cases came up later on, and we were asked to file 2 other amicus curiae briefs. These the NRA funded. We had full control of the proceedings, not them, but okay, life's getting a little more real than I ever expected when we started. Some of the things that have happened to our members since we've been about, and why it's become more political. One member was outside his home, and kids started throwing rocks at him because he was gay. Now, that doesn't sound too bad until you realize that a biblical form of execution used to be known as stoning. Another member of ours, living in a not-so-good neighborhood outside in the Boston suburbs, they had a pride flag out their front door, this lesbian couple. And the lady comes out to get her newspaper off her front porch, screened-in porch. And one of the gangbangers was hiding with a knife. And the moment they opened the door, he starts coming at her with the knife and saying, yelling, "I'm gonna kill you, bitch." She just reached down, grabbed a pistol, and shot. Ended up hitting him in the throat. Police justified it as a justified shooting. But these things do happen. And because it's become so real, I'm glad we can provide the cognitive dissonance that a lot of people need to get their mind around the concept that just because you're in one subcategory, that doesn't necessarily mean you're in the other. In the queer community, there's just as many people who use firearms as there are otherwise. Matter of fact, we've been welcomed as an organization by the gun community far more than the queer community as a whole. I have yet to see anyone in the gun community say boo to us. I have seen the queer community commit themselves into the press, saying we should not exist. Speaking of the press, because of just being there at the right time at the right place, I've ended up doing radio, TV, and print articles across the world, even picked up by Voice of America. I think my favorite article was printed in guns.ru, a Russian newspaper. Every single sentence was wrong, completely fabricated. We do not use gun mock-ups to teach people how to shoot. as an example. But as for the school shootings that we were talking about earlier that you mentioned, I think there's only one answer, and I think that's to go with the route the Israelis used. Bring the guns into the schools. It makes it a safer place. Otherwise, we're in victim disarmament zones. Did you know that when it comes to firearm incidences and accidents, more off-duty and retired police officers have them than your average concealed carry permit holder? We have a better track record than the retired police. I think that says something. Also, within the last 50, 60 years, gun attitudes, even within the city of Chicago, have changed dramatically. My grandfather used to be a preacher within the city limits. In the basement of the church was a rifle range. Can you imagine that happening now? And that was considered normal. Sure, it was only 22s, but one point earlier on, there's a Heartland, Illinois law, I don't think it's still there, that said to carry a firearm, you had to be concealed or packed up, unloaded, all the rest. Well, one of the approved containers was a fanny pack built with a built-in holster. So a gentleman decided he was going to put this to the test. He loaded the gun in his fanny pack and then loaded a clip onto his belt. So he was technically following the law. As he was going through Wheaton, a DuPage County cop saw him. And needless to say, he got arrested. Due to the nature of the gun community, I happened to hear about it within like 12 hours. I'm not sure why, but they went, hey, you can do something. Okay, what? Aha, press release time. And ended up putting out a press release and making sure that the DuPage police were on the facts list. Went out saying, man arrested for obeying the law. He was released the next day. One reason that I'm doing this is because by bringing an alternative face to the gun rights issue, it helps get rid of some of the discrimination. As an example, while I was living in Boston, Massachusetts is a may issue state. They don't have to issue you. A coworker of mine and I both went into the police department within about a month of each other. We have the same criminal record, that is to say, none. We make the same money. Only difference is we were living a little, maybe 4 or 5 miles apart. And yes, Boston is just as segregated as Chicago, if not worse. And he was black, I was white. I was approved for the firearm. He was not. And this sort of thing is a major issue, so I believe more people have to speak out. As for getting bused to the suburbs, from experience I can tell you that from the ranges I know of, there are no bus lines that go out there. And I was without a car and living in the burbs for the last 5 years. I just got a car less than 6 months ago. I know the PACE system really well. On a final thought, I remember one point a person in Boston happened to carry a firearm concealed riding the MBTA. And as he sat down, shirt tucked up, and went over the handle of the gun. No, completely an innocent mistake. Lady pointed it out, at which point he quickly put it down, and her partner was like, yeah, so, is it pointed at you? Thank you.
Okay, guys, now we're going to take some questions. So let's keep this brief, but who wants to start us off? Okay, I will. I guess this is more a question for the Illinois Carry guys. What does June 9th mean if nothing happens, nothing changes?
Well, if nothing happens, if nothing changes, that's the drop-dead date that was given by the Seventh Circuit Court of Appeals, whereby the certain provisions of unlawful use of a weapon become null and void. From a practical standpoint, theoretically that means that any individual with a firearm owner identification card can put their gun on their hip and walk down the street and go anywhere they want with their firearm, regardless of whether they have a concealed carry permit or not. It ultimately means generally unrestricted carry, constitutional carry, if you want to put it that way.
The people, the real avid gun owners basically are saying, you know, AR-15s down Michigan Avenue is basically what they're saying. That's not exactly true because there are certain municipal ordinances which were not, you know, involved in the Moore versus Madigan case, but effectively what you would have is you would have constitutional carry. You could carry anywhere you want, subject to all these little individual municipal restrictions. So it basically, in Chicago and in northern suburbs, it would really be unworkable because you would, so I live in Deerfield. Deerfield has no gun restrictions. I can have whatever I want. So I could theoretically walk around Deerfield with an AR-15 over my shoulder. No one would care. But as soon as I crossed over into Highland Park, they actually do have extra gun laws, and I'd be violating Highland Park municipal code. I wouldn't be a felony, but I'd still get arrested and charged with some kind of, you know, municipal misdemeanor. So we really do need to get a bill passed because otherwise you're going to have people like me, completely innocent otherwise, just, you know, want to defend myself, getting arrested for crossing an imaginary line on a city street.
Thank you all for very interesting perspective. If you allow me a quick comment and question. There is a video that was very popular on YouTube for a while, which gun rights advocates like myself were happy to see, but I found it also a little concerning. And that was a video of two men that broke into a video cafe. One brandishing a pistol and the other a bag. And there was this older gentleman, he doesn't do the Applegate, I won't make any more age comments. An older gentleman.
I'm 49.
Who reached into his pocket, stood up, and pulled out a pistol. And chased the two assailants away. The thing that I found concerning, I was very happy to see that he did that, but the thing that was concerning is he fired out an open door, which goes to your training issue. That was a concern for me seeing that video. Like, hooray, somebody stood up for the people in the room, but oh my God, those bullets could have gone straight.
I understand where you're going with this. We have the same concern with law enforcement officers too. We train private security personnel. We also do in-service training for police departments as well. And if you remember, at the Empire State Building, we had an active shooter situation there not too long ago, where the shooter goes in, shoots one person, walks away, his handgun's pointed down. He's confronted by members of the NYPD who end up injuring 9 other people in the gunfire, shooting at one individual. But generally speaking, what we find is that individuals that conceal carry generally are trained to a much higher standard than even police officers are, because a police officer goes to the range because his sergeant tells him to go. You have to go and qualify once or twice a year, and qualification, by the way, does not equate to training. It just means you can hit a piece of paper. People that carry concealed, a lot of these folks, you know, we're very much concerned about what we would or would not hit. And we go through a lot more training, and there are some individuals who are trained to a much, much higher standard personally than a lot of the police officers that only go when they're forced to go.
May I ask another question, actually one of the questions? We hear so much about disasters, but we don't hear except mom in the closet with her 2 kids that drops the guy with 5 shots into him. How many times guns have actually successfully defended somebody? You talk about a situation where a woman was assaulted. You never hear about it. Are statistics compiled any place where those of us that would like to advocate the benefits of gun ownership for self-defense would be able to speak with authority?
Well, to the best of my knowledge, there's no single organization per se other than the gun rights organizations, such as the National Rifle Association, Second Amendment Foundation, Illinois Carry, and the like, that compile these statistics. But what we also have to consider in terms of handguns protecting people is not just the use of the handgun itself. We also have to consider a situation where an attacker was scared off simply because a victim presented the handgun, and the presentment of the handgun caused the offender to disengage and flee. That also, you know, protects the individual from harm. But to the best of my knowledge, there's not a whole lot of data about that per se. I do know that the FBI does keep statistics on justifiable homicides, so that might be one direction to go.
There are people who have data along those lines. First of all, I probably got a couple of dozen examples of, but this were specifically for armed citizens who confronted mass shooting events, not so much the woman in Chamblee, Georgia, who shot the assailant recently while she was hiding in the closet with her kids. But John Lott, for instance, somewhat controversial academic, has written, among other things, a book called More Gun, Less Crime, and he compiled several examples like that. And there have been some studies about instances of lawful defensive use of firearms, but I could cite you several involving mass shooters who were stopped by law-abiding citizens carrying firearms.
I think there's a third aspect to it also, which even Andre didn't mention, and that's the deterrent effect, which you could never measure by its nature, is the dog that doesn't bark. How many crimes did not take place because there is an armed populace? 30-some years ago, I was in a convenience store in Tucson, Arizona, where a guy walked in the front door in camouflage pants, a sweatshirt with the sleeves ripped off, a gun on his belt, stood there like this in the opening of the doorway and yelled over the clerk, "Which way is the beer?" And the guy said, "Oh, Rob, you know it's in the back. Just go back there and get it." Arizona was an open carry state. People there used to joke at the time that it was unlawful to drive a vehicle without a loaded weapon and an open can of beer in the driver's seat, which is obviously a bad combination. But I suspect that that particular convenience store got robbed a lot less than the ones in my neighborhood in the South Loop. And nobody actually used a gun. Maybe Andre would argue someone presented a gun in that particular instance.
Actually, I'll give you a statistic along the lines of what David just said, which is you hear gun control proponents will sit there and say, well, there's a lot less gun violence in the UK because they have very, very strict gun control laws. And there are a lot of different answers that one could give to that. I will tell you that violent crime rates in the UK, not gun crime rates, but violent crime rates in the UK are much higher. Sex crimes, they use other methods of perpetrating death, such as strangulation rates. But the point that I wanted to make was, in America, about 13% of home invasions occur where the owners of the home are there. In the UK, that figure is 59%. Now, they ask people, why do you try to make sure that people are away? Robbers in this country, why do you try to make sure people are away before you engage in a home invasion? And the answer almost invariably is because we're afraid of being confronted with somebody who has a firearm. In the UK, it's the opposite. They want people to be home because they have extremely little fear that they are going to confront somebody with a firearm, but they want somebody who's going to have their wallet and will be able to direct them to their jewels, and they have no deterrence whatsoever about confronting a firearm.
I actually have a direct answer to that question. The Cato Institute has been putting together a kind of interactive map project where they document, gun use, self-defense gun use, deterring, home invaders and whatnot. And even they admit that this is really hard to track because most of these incidences are not actually reported. But I would check that out. It's on, I think, the front page of their website right now.
And if I remember correctly, the NRA a couple years ago said that the ratio was 98% of gun uses just displaying, brandishing the weapon, are never reported and take care of the incident.
There seems to be a split authority between circuit courts, obviously. How soon do you think the Supreme Court is going to address this issue, and how broad or narrow do you think the actual issue in front of the court is going to be?
It won't be this term. It may very well be the next term, and some of that will depend upon whether there are petitions for en banc review, which can also delay the process and gets the litigants an opportunity to get their ducks in order and get amicus briefs, amicus people behind them and the like. So not this year. Another term or two, it seems to me.
The New York carry case is actually in front of the Supreme Court now, the Kowalski case. That's the May issue case, which Posner disagreed with.
The Kowalski case?
Yeah, Kowalski. That is there now. They're still filing their briefs, obviously.
They haven't granted cert or denied cert, but
it's there.
The briefs are there, and even if they granted cert, they wouldn't argue it this term because they've now filled the calendar for the term. I don't know whether they're going to grant it or let this percolate, among the other circuits for a little bit first.
Well, thank you all for this panel. I'm a visiting student from Mexico, and coming from a place where we have a very large rate of gun violence, both related to organized crime and regular crime. One of the ways the government tries to discourage gun ownership amongst the citizens is by saying that gun ownership gives you some sort of false sense of security and that it might encourage regular citizens to act in a more dangerous way. Do you believe that there's any merit to this kind of thing?
Well, you certainly hear like a gun is an instrumentality that can be misused, and you certainly, there are, fortunately, very rarely gun accidents. You certainly hear about people engaging in road rage and what if they get this and what if they have guns in the classroom. Well, it's been pointed out, concealed carry is the law of the land in many of the states, not all of them, but many of the states, and incidents like that are very, very rare. There have been some discussions about guns in classrooms, right? Well, okay, in Utah, they've had guns in classrooms. You have to get a permit, you have to be trained, since the mid-90s, and other counties in Colorado and Texas since the middle of last century. Arkansas yesterday actually just approved allowing state universities to make this decision for themselves. And at the time, there was a huge concern, what if students go and grab the gun and they're in the drawers? And so far, not a single incident like that. So is it the potentiality? Of course the potentiality is there. The reality is, fortunately, it happens less often than people fear.
Every constitutional right carries with it a certain risk that there are going to be individuals that are going to misuse it, but that comes along with being a free state. You're always going to have that one-off where someone does something that is not within the intention of that particular constitutional amendment, but it's the cost we pay.
And that's one of the questions I would encourage members of the audience not only to think about, but to talk about with your classmates, your family, your friends. How much of your rights are you willing to surrender on the off chance that someone somewhere is going to abuse that right? We all pay a terrible price, in my opinion, at the airports today. As Mr. Bedell reminds me, I'm old enough to remember the day when you just walked onto the aircraft. Your family could walk up to the door of the plane with you, and you climbed the stairs and you got on, and you waved goodbye, and if somebody forgot a last-minute kiss, you could run down to the bottom of the stairs, or they could run up to the top of the stairs and do that. Nobody checked your carry-on luggage. Nobody screened you and took a look at you anonymously or otherwise, what you look like under your clothes, and saw whether you wear prosthesis in the process of checking to see whether you had any concealed weapons. So it's really a question. You've all heard the famous quotation that I will only paraphrase, that those who are willing to surrender freedom in the name of security will soon find that they have neither. And that's one of the questions that we as a nation, we as a people here in Illinois in particular, are confronting in a very direct and meaningful way. The legislature is obviously going to do something, whether it's going to do it in a caricature of a way that legislation should be passed and debated, or whether it's going to be done in a serious way with the thinking that Illinois really does not want to take its case to this Supreme Court. Maybe some state with better facts, better law, and perhaps a different composition in the Supreme Court would fare better if you were in favor of restricting gun rights. Nobody knows where this is really going to go. We do know what Heller says, we do know what McDonald says, and we know what Judge Posner has said. Everything else is pretty much an open question. I predict that the Illinois State Legislature will pass something by June 9. I am about equally confident that it will suffer some defects, and that someone will look for a test case, and whether it's one of the organizations represented on to the right of me on this panel, or whether it's one of you or somebody else, I don't know. But I expect we will see further challenges.
I'd like to pick up on something that Andre just said a moment ago, and I think it really deserves some emphasis. He said some people will abuse constitutional rights. A fancy academic way of saying the same thing is that all constitutional rights come with costs. Speech, for example, under the First Amendment, may result in people acting on that speech and engaging in illegal conduct. Under the Fourth Amendment, there may be people who have actually committed crimes who will be successful in their motions to suppress. We have a Second Amendment right. There will be costs. The question is, how do you regulate constitutionally, being cognizant at the same time of the extent of the cost? But I think that's a very important principle, and I like the way you said it, Andre.
I agree.
I know in other countries, some of their gun control laws are based on caliber. You can't own any firearms that are in a military caliber, so they just caliber. Is there any evidence, just seems like the same logic that comes up in assault weapons there? Is there any evidence that even drives any safety, or is it just another way for, gun companies to create more guns, different models to sell to more people?
Well, when we get into the conversation and a discussion of what constitutes a military caliber, well, the military, in many regards, they use a lot of the same calibers that ordinary folks use. The caliber of a firearm, for the most part, the type and kind that are available to civilians, because a lot of the military grade of ammunition is not available to civilians. There really is a separation of what you're going to see out on the battlefield in terms of ammunition versus what you're going to see available to most of the citizenry. But for a while, I know militaries had used 22s, 38s, 9mm. So given that great range, what constitutes a military grade round of ammunition versus what does not? So that's kind of a very broad. It's a broad way of really eliminating an individual's right to carry, in a sense.
I'm just aware that there are some differences. I'm not a huge expert in this area, but I know, for instance, that with respect to Operation Fast and Furious, which I know something about, there were particular weapons that were transported into Mexico called an FN 5.7 caliber pistol, and they were referred to as cop killer pistols because the bullets used in those pistols could pierce Kevlar vests of law enforcement authorities in Mexico. Those bullets are not available in this country for those guns, but they were readily available in Mexico for those guns.
Also, I would add that in many cases, all it takes to change the caliber of a firearm is to change the barrel. One piece, all of a sudden you need a new definition, and it's either now legal or not.
I think that whole discussion is really arbitrary because a lot of our modern firearms started off as military weapons. Like the 45 ACP was designed for the 1911, which is the U.S. military's sidearms until the 1980s. I mean, the 9mm Luger was used in Germany. I mean, to say what's military is I think it's just an arbitrary way of banning guns and banning ammunition to limit what's available to law-abiding citizens.
Yeah, although I have to say that a lot of the guns that fit within the assault weapons ban, I mean, the president, for instance, has referred to these as weapons of war. The First Lady misspoke the other day. She referred to these as automatic weapons. Again, they're guns that look mean, but they're not guns that we would give to our soldiers.
Point of clarification, the so-called assault rifles are mostly .223 and 5.56 caliber weapons, and sadly this is something that's not ever discussed. We just try to label something, and that's a really difficult thing to do, but I think that's actually a much better way to talk about it than we're currently talking about it. So
yeah, one thing worth pointing out, in the code where they define assault weapon, basically was based on the number of safety features. Flash suppressor, oh yeah, that's to keep my vision safe. Don't you want the guy
Pistol grip, so I can aim with it.
Yeah. Noise suppressors. Oh, so I don't lose my hearing. Those are legal in most parts of the world, just not here.
an adjustable stock, telescoping stock, so that a small person or a large person can use the same gun. I have a 12-gauge shotgun that's got an adjustable stock on it. It's adjusted for me right now, but if I wanted to, I could adjust it so that my wife could shoot it.
That's right.
That sort of thing would be banned under the assault weapon ban.
Okay.
All right, do we have any more takers? Okay, well, thank you very much, guys. We appreciate your time.
Thank you.
And your expertise.
Thank you.
Have fun at the theater tonight. Oh, I will, and you're probably visiting friends.